Rules that control deliberations. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. Your first task will be to pick your foreperson. The foreperson should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with the other members on the verdict, and sign the verdict sheet. You must communicate with the judge only in writing, signed by the foreperson and given to the judge through the officer assigned to you. You must not conduct any independent investigations, research, or experiments. Do not look up any words. Do not post information about this case on the internet. Do not share any special knowledge or experiences with other jurors. Your sole duty at this point is to determine whether the defendant has been proven guilty. You must restrict your deliberations to this matter. You must not let bias, prejudice, or sympathy play any part in reaching a verdict in this case. To reach a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching a unanimous agreement, if that can be done without violence to individual judgment. During deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. After you have arrived at your verdict, you may use the form attached to these instructions. You should have your foreperson sign his or her name to the appropriate verdict. After a closing argument by the attorneys, you will begin your deliberations to decide your verdict. Signed by me, Tanner Neidhardt, 483rd Judicial District Court, Hays County, Texas. Verdict of the jury. And this is the verdict form that I told you about. We, the jury, unanimously find the defendant, Joshua Patrick King, guilty of the offense of aggravated assault as charged in the indictment. If that is your verdict, the foreperson will sign that line. Or we, the jury, unanimously find the defendant, Joshua Patrick King, not guilty of the offense of aggravated assault as charged in the indictment. If that is your verdict, the foreperson will sign that line. State, are you ready to give your closing argument?
Can state have a minute to set up the courtroom?
You may.
Mr. Johnson.
You can hear me? Judge,
You may proceed.
drunk people shouldn't use guns. Drunk people shouldn't use guns against others who are just holding beer. Drunk people shouldn't use guns against others who are just holding a beer 7 to 8 feet away from them. I mean, that's what this case intends. Drunk people shouldn't use guns against people holding a beer when they're not doing anything threatening. Even if they're arguing. Because one of the things I'm going to keep coming back to today is that verbal provocation alone is not enough to get to self-defense. Drunk people shouldn't use guns. So let's talk about how we're going to do it. We got a roadmap. As a state, we've got to prove aggravated assault. Step one, we've got to prove all the elements of that. Step two, we have to disprove the defenses that have been brought up to. Deadly force in self-defense and deadly force in defense of the third person. Those are the two. So let's start with the easiest thing. Did we prove the elements of aggravated assault? Okay? And this is actually pretty easy in self-defense cases because to raise a defense, the defendant has to admit to most of the facts to even get to use those. So, is there any doubt that this happened on May 22nd? You heard all the officers. You saw the medical records. This occurred on May 22nd of 2020. Here in Hays County, Texas. You know where the apartment complex is. It's actually right down the road, across I-35, across from that road. It's here in Hays County. That the defendant intentionally, knowingly, or recklessly caused bodily injury. I mean, he said in every single statement that got the gun, he held it out, he pulled the trigger, and you saw medical records that it caused bodily injury to JC, to Juan Carlos Rodriguez. And that he used a gun to do it, which is a deadly weapon. And we talked about that all the way back to work. And so you shouldn't have to spend much time at all talking about the elements of aggravated assault. And I don't even expect defense to spend that much time on it, because what we're here to talk about really is does the defendant get to use the defense, deadly force against others, or deadly force in defense of a third person? So before we get into that, I want to stop and talk about beyond a reasonable doubt and what a reasonable doubt is. Because in Texas, we don't have a definition of it. You guys get to come up with that on your own. But there's some questions I want you to go through when you're thinking to yourself, if you have a reasonable doubt. Question number one is, do I even have it? Okay? And if you do, this is the main one I want you to focus on. Does it go to an element of the offense or the defenses? Okay? If it doesn't go to an element, it actually isn't a reasonable doubt. Okay? So, for example, I think a good example of this is, where was Peyton when this offense occurred? Was she in the backseat of the car? Was she over by the stairs? That actually doesn't go to an element. She could have been in either place, and self-defense with deadly force or self-defense of others could still be in play. So where she was exactly, based on all the statements we've heard, doesn't go to an element or the defenses. And is that doubt reasonable? Those are just some of the things that you can think about when you're saying, is this doubt that I have actually? I want to talk about something before we get into it. What's not a defense? Voluntary intoxication. In Detective Campbell's statement, and I wrote it down, you can listen to it again if you want to. Josh said, I had 5 beers, 4 Irish car bombs, and it's at 53:16 on this disc. That's how much you have to drink that day. 4 Irish car bombs, 5 beers. He doesn't get to use that as a defense. And we're going to talk about intoxication, because we're going to say that that actually makes somebody pretty unreasonable. 9 beers, 4 shots over one night. Self-defense. A person is justified in using force against another when and to the degree the actor reasonably believes that force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. And really, we're talking about 3 words here. The actor reasonably believes. And what's important about this one phrase, and we're going to keep coming back to it over and over again today, is that it's actually a 2-part test, okay? Part of it is subjective, part of it is objective. The subjective part, the actor believes. Did the defendant actually believe in his own mind that he needed to pull that trigger? And I don't think there's going to be a lot of argument about that, because he did. And he did. He subjectively pulled the trigger. He subjectively thought he needed to pull the trigger, and he did, and he shot long cards. But what you are here to do today is you're actually that objective test for us. You're the 12 people that we're going to say, was what the defendant did reasonable? And you actually get a definition of this jury charge. Reasonable belief is a belief that would be held by an ordinary and prudent person in the same circumstances. And I want to add a little caveat to that. Because that reasonable, prudent person in the same circumstances is sober. Because voluntary intoxication is not a defense. So, as the 12 people chosen from this community to think about this case, you need to say, as a sober, reasonable, prudent person, is what the defendant did on that night reasonable in our opinion. The 2 defenses that we're going to be talking about are deadly force in defense of person and deadly force in defense of a third person. And they're very certain. Because you can use deadly force when you reasonably believe that deadly force is immediately necessary to protect yourself from unlawful deadly force. And for defense of a third person, you can use deadly force when you reasonably believe that deadly force is immediately necessary to protect another from unlawful deadly force. So you're just changing out the people. If you believe that you could use self-defense with yourself, you can still defend somebody else in the same way. So don't get caught up in the language being a little different. If you can use deadly force to protect yourself, you can use deadly force to protect a third. And all of it's going to come down to what was reasonable that night. So let's talk about what happened that night. Everybody agrees, and we've heard no contradicting testimony about honestly what happened from the beginning of that night all the way up until them pulling into that apartment complex. They went out to Sean Patrick's, and everybody started drinking. Then the defendant went to work for a couple minutes, around 30 minutes. Then he meets back up with the group. They were going to go to Craft House, but they decided, the line's too long, let's go back to Sean Patrick's. So they go back to the bar a second time. Then they realize, okay, you know what? Let's actually go drink some more beer, and let's go to the top of the Vistas apartments. And so they do that. They go to the top of the Vistas apartments that night from around 10 to midnight, and they continue to drink. And then after that, they say, you know what? We're not done drinking tonight. Let's go do more. So they go to the Green Parrot and drink some more. And it's at this point that everybody decides, okay, it's around money I need. Let's get out. And everybody agrees. Shocking that Juan Carlos Rodriguez is the most sober person in this group, and that he should drive home. And we know how drunk he was. We saw his hospital blood. He had a .22. He was almost 3 times the legal limit. But everybody in the group thought that he was the most sober. And they let him, the defendant, let him, Juan Carlos, drive him home. And they get to the apartment complex, and this is where we start to get, there's 2 statements on this CD, 1 statement on this CD, 1 statement that was written with his attorney. You start to get different stories. But let's talk about the facts about what happens when they pulled into that parking spot, okay? We know that they were there for long enough at least that Juan Carlos could get out of the driver's seat, walk around, grab a beer from the passenger seat, because that's where the Miller Lite box was, or have the defendant pass him a beer so that he could grab that beer, go over to the parking spot that they were going to talk in, crack it open, and start drinking. We know at least that much time passed. We know that the victim, in this case Juan Carlos, gave the keys to the car back to the defendant because the car keys were found in the front passenger seat. There's photos that you can look in and see that. We know that some conversation happened because I want to point out, look at how much beer spilled out of that beer can on the ground. It was almost empty. So these 2 individuals, Juan Carlos and the defendant, had enough time to sit in this parking spot and start talking to each other to where Juan Carlos, during apparently this heated argument, is sitting there drinking a Miller Lite. But it was almost empty. I think this is so important. Because what the defendant wants you to believe is that right when they got to the apartment complex, the things changed right away. That things started to get heated. That he started talking about a sacrifice to God. That he was going to rape Peyton. That things just went to shit right away. No. That's not what happened. These were 2 drunk individuals that were sitting in a parking spot drinking beer with each other. That's what the evidence shows. That beer can might have saved Juan Carlos' life. You heard from the doctor on the stand that if those bullet fragments had hit that renal artery, had he gotten sepsis in the hospital, it would have been a very different case in point. Holds a beer can with his left hand, and we know that because of a bullet wound to the victim's left hand. Top of his finger. I don't know. I honestly sat and thought this whole trial, how do you get to self-defense thinking that Juan Carlos was about to use deadly force against you when he's holding a beer in his left hand? How? I honestly don't know. And you don't even have to take my word for it. Take the defendant's own words for it. Listen to his statement on the curb at the crime scene. Listen to his statement to Officer Melendez at the police department. Listen to his statement to Detective Campbell. Listen to the words that he put down on the page that his lawyer gave to the detective a week later while he was sober. In none of those statements does he say that Juan Carlos Rodriguez used the word attack or hurt or harm or tried to tackle him or grapple or rush or lunge or throw the beer can or pull his knife or even had a knife or he's coming at him with a weapon or be in anything that would allow a self-defense. None of those words. Watch all the videos again. Read the statement again. At 54 minutes and 53 seconds in the defendant's statement with Detective Campbell, knowing what he was investigating, said, all right, but you're not really remembering specific comments JC made to you. What were they? The defendant said, no. All I can tell you is it wasn't normal, along the lines of, I'm not going anywhere. Question, did he make any physical threats towards you or towards Peyton, other than physical advancements after I asked him to stop and the fact that I'm not going anywhere? Detective Campbell said, all right. Wouldn't that have been the time? And even if he forgot and had days later, like we've heard in Officer shootings, they get 2 days to write their statement. We did. You have no time. You wrote a statement. Look at it. Read it. I kind of get to be the one for the state that talks about the police. He's going to come up and talk about some more specific trees in that forest, but don't lose sight of this fact. Drunk people don't get to shoot others that are holding a beer, they do not get away. Even if they're saying crazy stuff. Even if they're saying crazy stuff. Even if you believe that Juan Carlos said, what are you going to do with that gun? Shoot me? Fine, just do it. It's not enough. No words you can say are enough. He had to believe that deadly force was about to be used. He never said it. He never said it. And so a reasonable person, a sober, reasonable person, we can say, you don't. If you don't get the defense, and you agree to all the elements of aggravated assault, your job actually becomes clear. Your job becomes to tell him what you did that night is not okay. What you did that night, we don't want here in Haines County. We don't want drunk people handling guns that way. Half of you on this jury have guns, half of you don't. I hope whether you own a gun or not, we can agree that drunk people should be using guns this way.
Vince?
Thank you, Your Honor. May it please the court, opposing counsel.
Mr. Watts.
Yes. Ladies and gentlemen of the jury, part of what the state is implying is if you've been drinking, you're not allowed to defend yourself. You got a charge from the court. Nowhere in there does that say that's the law. It says voluntary intoxication is not a defense. But just because you have been drinking does not mean you can't defend yourself against another person. It also doesn't mean you can't defend your fiance, your significant other, or the love of your life. The state gives a version of the case which is based on their fiction perception of what occurred. And part of what the state told you when they were reading the charge, I found this interesting, was reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances. What they left out repeatedly is as the defendant. It's the same circumstances as perceived through Joshua King's eyes. So let's go back and let's talk about that night. Joshua, Peyton, his fiance, now wife, went out to celebrate. Peyton becoming a teacher. The bars had just opened after COVID. We don't have to rehash the restrictions of COVID. We all lived through it. They went out to Sean Patrick's. He went to work for a while. They were drinking. Some of the best victims of crime are people who are impaired and can't necessarily defend themselves completely. They went back to Sean Patrick's and they met Juan Carlos Rodriguez, a 33-year-old man who was just so sweet, so wonderful to these 22, 23-year-old young adults. He was so attentive to them. So attentive, hey, Joshua, I think, may have been a bit naive. You need to be aware of your circumstances. You need to be aware of the people who are around you. But Joshua was a trusting soul. And in Juan Carlos, he thought he meant a friend. So they go and they sit and they talk and they drink and they have a conversation. Juan Carlos has identified himself as basically a loner. He doesn't have any friends. He just went out onto the town because first night bars are open, he's going downtown. He takes his buck knife. He takes his tactical punch, which can be used to knock people's windows out. He's going down and he meets these young, impressionable kids. He drinks with them. He starts telling them about himself. He tells them about the fact he's been to prison before. He even mentioned to Peyton, should have been there longer. Kind of a weird statement to make. But that's what he mentioned to her. And they drank. And then they wound up going over to, I believe it's the View. You can get up, it's about a 5-story apartment. It's got a great view, hence the name. They hung out there and they had more to drink. Then they went back to town. I can't remember if it was the Green Parrot or Sean Patrick's. They drank more. And at the end of the night, they were going to go home. Part of the issue in this case was Juan Carlos up to something other than just being the super sweet little friendly guy he presented himself to be. That's where the videotape comes in. If you have the intent to meet somebody and commit a crime, the last thing you want to do is have a picture of your face so that you can be identified. Those kids were there at the table. They have the video camera out. Ha 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 ha. Juan Carlos did everything he could to make sure there was not a picture of his face. He physically tried to stop the camera from recording him. So at the end of the night, it's time to go home. Peyton's intoxicated. She is inebriated. She is fallen asleep. She is vulnerable. They're going to catch an Uber back, but Juan Carlos, being the wonderful person he is, says, no. I'll drive you home. And I'll just catch an Uber back. Josh is, hey, that's great. We don't have to bring our car back or get it the next day. I'll pay for an Uber, no problem. Peyton gets in the back seat and she falls asleep. They drive home. They have beers in the car. Juan Carlos has been watching and paying very special attention to how intoxicated Peyton is. And this is from his words. And he was paying so much attention to Joshua King, he was even watching his eyes to help gauge how intoxicated Joshua was. And Joshua is already a vulnerable individual. He's a vulnerable individual because his eyesight ain't so good. It's hard for him to see an attack coming. Joshua, Peyton, and Juan Carlos go back to the apartment. At this point in time, there's a car there. I don't think there's any confusion about who was passed out in the back of the car. Joshua tries to get her up to get her into the apartment, but she's too intoxicated. So Joshua is there. The love of his life is in the backseat of that car. She is passed out. She is vulnerable, and he is her protection. And Juan Carlos is not done for the night. Juan Carlos is not going away. Let me get you an Uber. No. Okay, well, maybe you can sleep on the couch. We'll lock the door of the bedroom. It's not good enough. Look, this is getting weird. I need you to go away. We're not done. We are not done. When the state made their opening, they told you basically just out of the blue, no reason, Joshua King pulled out a gun and shot him. We know from Juan Carlos that they were probably in the parking lot for about 30 minutes. And according to Juan Carlos, Joshua King had the gun pointed at him for about 15 minutes. No reason. He just happens to have a gun pointed at him. Now, I don't know about your experience, but it would seem to be a little odd if you're over at somebody's apartment complex and they pull a gun on you and just, oh, hey, how are you doing? Let's have a beer, whatever. Is that how it works for you? And if somebody pulls a gun on you, you think you might want to get a little distance between you and them, so you don't get shot? Now, according to the evidence, Joshua King was telling him, leave, get away, get the hell away. If you do not get away from us. I will defend myself. And by virtue of the fact he is the only defense for Peyton, who is passed out and vulnerable in the backseat, he will defend her. What did Juan Carlos tell you? I didn't think he pulled the trigger. His assessment of Joshua King was, number one, he didn't have to be finished with the night because he wasn't finished doing what he was going to do. And I suspect what he was going to do was Peyton. Because what's going to stop him from doing whatever he wants to do to Peyton King? Some guy who can't even drive a car because his eyesight's so bad? Some guy who, even if he pulls a gun and says, I will protect my loved one, I will protect myself, he don't have the huevos to pull the trigger when the time comes. Juan Carlos told Detective Cameron, this was all just a conversation. It's all just, we're just talking. That's it the whole time. Well, herein lies the problem. The resident at the apartment underneath, Chavarria, hears it. And it's not just a conversation, it's an argument. When Juan Carlos was on the stand, he was being asked questions. It was an argument. When the state asked him questions, it was an argument. When we asked him questions, it was an argument. So they're having an argument. What does common sense tell you that Joshua King is telling this individual when he's pointing a gun at him? If you perceive that someone is a threat to you and your family, and you pull a gun, do you try and get them to leave without you having to pull the trigger? Probably. How would you do that? Back the heck off. Now, if you want to buy the state's theory, and that's what it is, and this is a court of law, they have to prove it, they have to prove it beyond a reasonable doubt. What they have is kind of he said, she said. Unfortunately for them, Juan Carlos's statements validate Joshua King's perspective. Chavarria, when he talks about them outside, he gives a description of where they were and approximately how far apart. And my recollection is it would put it around 15 feet. But when he was shot, they were closer to 8 to 6 feet. Now, Joshua's King's position is he was coming at me. He was coming towards his fiance. He had told him to stop. And according to Juan Carlos was telling him, go ahead and do what you're going to do. Just do it. Just do it. Juan Carlos was coming at Joshua King. It is immediate. It is necessary. You do not get more imminent than when a person is coming at you and you are holding a gun on them and they think they're going to be able to take you because you don't have what it takes to pull the trigger. And the simple reality is we don't know whether or not you do have what it takes until it actually happens. One of two things happens. When you're holding a gun on somebody and you're telling them to back the heck off, and they continue to come at you, one of two things happens. You pull the trigger and stop the other person, or you become a victim. You don't have to be a victim. That's why we have laws. It's not a privilege, the right to defend yourself, the right to defend your loved ones. It's a right. So let's think about the state's case. Juan Carlos is shot. He is taken to the hospital, and while he is in the hospital, officer, I may confuse their names, and I apologize for my memory, but one of the officers goes and they talk to him. They want to know what happened. Why did this guy shoot you? What's his response? Well, he thought I was messing with this girl. Yeah. So the police asked the follow-up question. And you can pretty much guess what that is. What are you doing to his girl? What's his response? Get the F away from me. Officer Campbell told you from the stand he would take that as an assertion of a person's right to remain silent. Juan Carlos, when asked what he was doing to the girl, told the cops to F off, I'm not, get the heck away from me. What was Juan Carlos not willing to discuss? Because what wound up happening is Officer Campbell, in his investigation of the case, goes and he sees Juan Carlos and talks to him in an interview 2 weeks later. And Juan Carlos presents it as, he just shot me. Out of nowhere. Although that contradicts what he told on the stand. Out of nowhere. Events don't just occur in a vacuum. Okay, there's a reason why he was shot. Juan Carlos was going to try and take the gun from Joshua King. And let's face it, he's been drinking, he's got bad eyesight, he's an easy mark. After he takes the gun from King, what are his options? If you buy the state's theory, well, I guess they're just going to sit and sing Kumbaya. Maybe they're going to be best friends forever with the passed out vulnerable girl in the back seat. They'll have Yahtzee games. Run the analysis. What can happen? Joshua King can be killed. I asked Detective Campbell, have you ever been in a situation where somebody tried to take your gun from you? Yes. What's the danger? They can use the gun on me. They can use the gun on someone else. Juan Carlos went at Joshua King because he didn't think Josh would pull the trigger. And Joshua did. So today, he is being tried by 12. But if he didn't pull the trigger, he may have been carried by 6. His funeral. And then let's think about what would happen to Peyton. The love of his life that he depends on, because as she put it, if they are lost in a crowd, she has to go get Peyton, because Peyton probably can't even find her because of his eyesight. If you want to give yourself a headache, try wearing his glasses for 5 minutes. He's not blind as a bat, but he's legally blind. He can see some. You've been watching him while he's sitting at council table, and when he's writing his notes, he has to be roughly 4 inches from it to even see it. The government has the burden of proving their case. They have the burden of disproving that Joshua King was exercising self-defense. We attempted to solicit testimony about reasonable use of force, the dangers that a person represents to you because of proximity. They talked about the 21-foot rule. Well, from my understanding at the time they were shot, it's 6 to 8 feet. How long would it take for someone who's 6 to 8 feet to get you? Could you even react before they make contact with you? The state of Texas makes a big deal out of the beer can. Sorry, the beer can died. But here's what I find curious. The beer can was in his left hand. Wouldn't you normally use your dominant hand if you're holding a beverage? So then the question becomes, why do we think that Juan Carlos was right-handed? No, statistically, most people are. But let's not think about statistics. What was on the right side of his hip? His knife. And a knife, like a gun, you put it on the side that you can use it. If you're a right-handed person, your knife is accessible to you. If you're a left-handed person, you put it on your left side. Juan Carlos, when he came at Joshua King, the beer was in his non-dominant hand, leaving his dominant hand free to deal with Josh. So, we tried to present evidence about reasonable force, threat distance, stuff like that. We don't have to. But we thought it was important that you know. You know who hasn't presented any evidence whatsoever? From a police officer, from an expert, from anyone, that this was an unreasonable use of force? Ironically, the people who carry the burden of proof. They are the ones who have to prove this beyond a reasonable doubt. And the way that they move to attack the case is, who was it? Officer, I'm going to mispronounce his name, Deadcourt, who's not Deadcourt, officer who was up here, he's a police training officer. He trains other cops. And it just baffled me when the police went and they shredded him. He doesn't know the law. He doesn't know about use of force. Can you cite what 3226 of the Texas Penal Code says? By the way, you don't have to remember every penal code. That's why it's in book. You actually look it up and go, hey, that's what it says. But they attack their own law enforcement officer, basically saying, you don't know what you're talking about. You don't know what the law is. Ironic, because these are the people we depend upon to protect us. And when all those police officers responded, all those people went out there, not one of them made the call that Joshua King needed to be arrested because they all knew it was an issue of self-defense. And that one of those officers went and talked to Chavarria, and what did they tell Chavarria? You will have a detective get in touch with you. The detective didn't even know the witness existed when he testified. A witness who could have confirmed what was being said, because it was just a few feet outside of his window. A witness who confirmed this was an argument, not a we're sitting here having a beer and the guy pulled out a gun and shot me. If Joshua King had not acted, that lady you see on the front row in the green outfit, I suspect she would be a shell of the human being she is today. Because she would have enjoyed, no, she wouldn't. She would have endured what it's like to be taken, violated, and abused. And in hindsight, it was the right call. Was it the right call at the time? Absolutely. How do we know that? Let's talk about that charge. It says, reasonable belief means a belief that is held by an ordinary and reasonable person in the same circumstances as the defendant. So, let's presume you're reasonable, prudent people. You go out on the town with your loved one, your significant other. You go drinking and you meet somebody who's a lot older than y'all. And he's just so sweet. He really butters it up. And y'all are getting along fine. And he's just being the most wonderful person in the world. And then you need to go home, but you've been drinking. And you go home and you pull in your driveway, you pull in your apartment complex, and you need to get your loved one into the house, but they're passed out. And you go, okay, I appreciate you, appreciate everything you did, had a wonderful evening, but it's time for you to go. They're like, we ain't finished, honey. We got other things we want to be doing tonight. And you're telling them, no, that's not happening. You need to go. Mm-mm. I'll get you an Uber. No. Not happening. So you go and you retrieve your gun from the center console area. By the way, there's a photograph that shows the holster. It's in the center console area. So I don't know what the deal is with where the gun was. It was in the center console area. It's probably took it out of the holster. And you point the gun at the other person. You tell them you need to back off. I do not feel comfortable. There was an issue about was he going to make a sacrifice. I think that's actually on the video with Melindres at the beginning. And you tell him back off. But he's not backing off. He's pacing. According to Juan Carlos, he uses his hands a lot. No, not backing off. Not going anywhere. We're not done. We're not done. Back off. According to Juan Carlos, this happened for about 15 minutes. Back off. Get away. If you continue what you're doing, I will defend myself. You will defend yourself. Yeah. No. Is God forgive you when you're dead? Not leaving. Not leaving. At the same time, Juan Carlos has been making the calculation, you're intoxicated, because he's been watching him all night long. He's making the calculation, you're not going to be willing to pull the trigger because you don't have it in you. And then he makes the calculation, I'm just going to keep getting closer because you're not pulling the trigger. And you're not pulling the trigger. Until I'm so close, one of two things is going to happen. You're either going to pull that trigger or you're going to become a victim. And to his surprise, and Juan Carlos told you this, that he was surprised. He even told you that he didn't think Joshua King meant to shoot him. To his surprise, he got shot at the center mass. And that stopped him. And because Joshua King pulled the trigger, he did not become a victim that night. And his fiance didn't have the worst experience in her entire life. And it was within his rights. And if you were in the same shoes, the question for you is, when it comes down to it, and you have a gun on a person, and they are approaching you, and they are telling you, go ahead and do it. Just do it. They have committed all in. Death is on the table. Yours or theirs. So he pulled the trigger. Juan Carlos goes to the hospital. By the grace of God and the fact that it was a .380 and not a heavier caliber pistol, he's still alive. And we're grateful for that. So Juan Carlos, he's real upset about this, right? He got shot. This is terrible. What's Juan Carlos's position? I forgive him, it's no big deal. I forgive him completely, it's no big deal. As a matter of fact, Juan Carlos, why are you here? Well, I'm here because they told me if I don't come up here and testify, I have to get my bills paid.
Objection, Your Honor, that's a misstatement of the evidence.
You'll remember the evidence, how you heard it. Defense, you may continue.
Thank you, Your Honor. You heard Juan Carlos. The discussion about him getting the medical bills paid. Forgive me, I need to refresh myself with my notes.
Sir, you have 5 minutes, 20
Thank you, Your
seconds.
Honor. I want to talk to you a minute about trauma. There is no doubt, I suspect, from anybody who's viewing that evidence, Joshua King was traumatized by this event at that time. You are a peace officer and you are involved in a shooting. You have a minimum of a 48-hour break before you're asked to discuss the case. And the reason for that, per Detective Campbell, is because of the trauma that this sort of an event does to the mind. It affects a person's memory, their perception, and it takes that time in order to put the pieces back together. But under the duress of that trauma, under the duress of having been taken down by the police, dealt with as a potential criminal, he did everything he could to cooperate with the police. He was terrified of the threat Juan Carlos represented. And he did, in fact, represent a threat. The question you have to ask yourself is, when you are holding a gun and someone is coming at you, what do? Do you pull the trigger? Or do you allow them control over your body, your fate, and your destiny? Joshua King said, in the same situation, he would do it again. One of two things happens. You pull the trigger or you don't. If you don't pull the trigger, you become a victim. If you do pull the trigger, you may wind up in front of a jury. But if you love your loved ones, you protect them. And he did. Joshua King didn't want to be in that situation. He never wanted to have to pull the trigger. He never wanted to have to pull the gun. But just because he was drinking does not mean you get to victimize him or his fiance. We pray that you make the right decision. Speaking of prayer, they made a lot of issue about how religious Juan Carlos is. Well, guess what? Joshua King had a cross on that night too. And when you look at the pictures of the car, there's a cross hanging from the windshield. And because of his faith, he had faith in another human being, and he trusted him. He trusted him until the minute that he figured out he could not trust him anymore. And then he defended his family. And because he defended his family, he is here today, and we are here putting his faith, his life, and our rights in your hands, and asking you to return a verdict of not guilty. Did he shoot him? Oh yeah, he shot him. Was he legally justified? 7 days a week, 365 days a year? Absolutely yes. Because when somebody comes at you, you need to decide, are you willing to pull the trigger, or are you going to become a victim? Nobody deserves to be the victim of rape. Nobody deserves to be killed. And the fact that the state of Texas has a theory that this wouldn't be justified, if we just ignore all the evidence of justification, doesn't make it a reality. Return a just and appropriate verdict. Because if you were in his shoes, would it be reasonable for you to defend your loved one and yourself? I think the answer is absolutely yes. The only question is, when the day comes, can we actually do it? And that's something we don't know until there's hindsight. Thank you.
State. 2012 remaining.
Did I still have time left?
Oh, I'm sorry. Yes, you have 120.
1 minute, 20 seconds?
Yes.
Thank you, Ron. I just want to make sure I heard you correctly.
Yeah.
I'll take the 1 minute and 20 seconds.
There we go.
On the jury charge, you're determining whether or not.
Mr. Navarre.
May, is that, okay, thank you, Your Honor. On the jury charge, what you're determining is whether or not Josh's actions were reasonable, right? So were you gonna be going on the jury charge, you're gonna be going to self-defense? And it says, you're instructed that the defendants believe that deadly force was immediately reasonable, is presumed to, let me stop, was immediately necessary, is presumed to be reasonable. The state must disprove all three of these things. If the state does not disprove all three of these things, you're gonna start your conversation back there believing that Josh's actions were reasonable. So that's one thing you really need to pay attention to. The page where it talks about the presumption of reasonableness, I ask you to look at that, read it, talk about it. If the state does not disprove all three of those things, when you start your conversation,
Objection, that is a misstatement of the law. I only have to prove one of those three in the negative.
it's in the jury charge.
You have, you will have the law with you. You will take that back to you. That will be your guide and reference as you make your decision.
And your guiding reference would be, the presumption of reasonableness applies unless the state proves beyond a reasonable doubt that the facts giving rise to the presumption does not exist. Further down, if the jury has a reasonable doubt as to whether the facts giving rise to the presumption does not exist, the presumption applies. So that's where you're gonna start off with your conversation, with the presumption of reasonableness, if the state does not disprove all those. And then if the state did, then you think about the second part. You think about reasonableness. And that's where your experience comes into play.
That's 40 minutes.
Thank you, Your Honor.
Drunk people should not handle firearms.
Objection, Your Honor, this statement of the law. There's no proof that Josh was drunk or intoxicated. There's only proof of consumption of alcohol.
No, that's argument.
You will take the law from the guide that I have given you. You may carry on.
Drunk people should not handle firearms. This is the result. What happens when people use firearms irresponsibly puts our community at risk. Innocent people can be shot and can be fighting for their lives for 8 days in the hospital, having multiple surgeries just to live. Stapled up, had a horrible recovery. That's what happens when we use firearms irresponsibly. We do have a right to self-defense under the law, but you have to follow the rules that go along with that. It is a proportional response. It is something that requires
Objection, Your Honor.
deadly forces.
That's a misstatement of the law, Your Honor.
You have the law in front of you.
It is a proportional response. And typically that requires one of two things, and we've already gone over that. Deadly force is being used against you, or you have some major crime that's being committed that you need to protect yourself or another individual against. So let's talk about what was going on that night. We had a 137-pound man who is described as looking like a 13-year-old boy by the defendant, holding a beer can. We know that the bullet went through that beer can, and we know approximately where it was placed because he was wearing a cross that night, and he was wearing a dog tag. And you can see that it went through this beer can, straight into his chest, and it's actually bent. Reader, it shows it went down after hitting. We know also where everything occurred. Here's the best picture of that. We have everything occurring at the very bottom of this vehicle. We have the cross found in that location. We have the beer can and we have the dog tag. So we know that the victim is all the way down in this area. We have shell casing found right up here. We know that the defendant was somewhere in this area when he was shot. There is a massive size difference between these different individuals. We have a approximately 245-pound man and a 137-pound individual. We know that although the defendant does have some disability regarding his eyesight, he was able to participate in high school in both football and wrestling. This is not a defenseless individual. There is no way that this 137-pound individual was going to charge and try to take a weapon from this man. Now, we really need to talk about what's reasonable in this situation. We could have brought you an expert. However, the jury is the one that decides what reasonable is. Ultimately, you are the decision makers. You are the one that makes that decision, not an expert. They did not hear all the testimony. They did not review all the evidence. They did not review all the statements. That is your decision. What we have here is a 245-pound drunk blind man shooting a firearm at a 137-pound individual with no weapons in his hand. We know that according to the defendant's own statement, the victim was actually moving to the right in that parking lot space. He went in an L shape, is how it was described. So he moved over this way. He wasn't coming at him. In the defendant's own words, he was coming to the right, and ultimately, there was no way that this was immediately necessary. And how do we know that? We know that because the defendant had to literally go into the vehicle, open the center console, grab the weapon, come back and pull it out. If Juan Carlos was charging at the defendant, as the defense attorney would like for you to believe, there would have been no time for him to have pulled this out. We know that saying weird things does not mean that another individual gets to pull a weapon out on us. We know that this whole prison thing that keeps being brought up wasn't even a big deal to the individuals involved, because it wasn't even mentioned until the fourth statement on the part of the defendant, after he had a chance to talk to his attorney. The knife and the tactical pen are also just things to distract you from what really happens that day. In all four of these statements, the defendant never mentions that the victim had a knife. But do you know who was honest and upfront about the fact that they had a knife? The victim. The victim told that. But it wasn't a big deal to the defendants. They were essentially playing show and tell with their toys at the bar. Today, we are trying to make sense of a drunk man's decisions. They are not going to be reasonable. We are not going to understand why something, when they were all getting along, according to everyone, suddenly blew up in everyone's face. Because drunk people don't make good decisions, and drunk people don't act rationally. And when people are drinking, people do things that they wouldn't normally do, and they can do things that just don't make sense. There is no information anywhere in any of the statements to describe why the defendant thought his girlfriend was getting raped. A little bit about some of the defense arguments. The defendant wants you to believe that the victim was engaged in criminal activity because he didn't want to be in a video and didn't want his identity to be known. If that was the case, why did he tell everyone his full name? It just doesn't make sense. He also talked about how the victim just wouldn't retreat. Where was the victim supposed to go? He had no vehicle. He was in a place that he wasn't familiar with. Where is he going to retreat to? The victim also mentioned that he thought that Joshua wouldn't pull the trigger. And that actually makes sense, because this is the second time in the night that the defendant has pulled out a weapon in front of him, and the first time he didn't shoot him. The argument that the victim was charging to take the gun makes zero sense considering the size difference, considering the defendant's training on football and wrestling and all of those different things, and considering the fact that the victim even knew that he had a gun on him because the defendant had previously shown that gun to him in the car. The defense attorney also wanted you to believe that that description of the argument happening in the parking lot is important. It's not. Eugenio described all of this as loud talking. They were having a discussion. They made it loud. They were loud enough to make someone wake up. But the fact that the victim didn't describe it as an argument makes sense because Eugenio originally on direct didn't either. Regarding the fact that JC said that he didn't just go ahead and do it whenever he had a firearm pointed at him, doesn't really matter either. First of all, you can't consent to the use of self-defense, meaning he couldn't have consented to have been shot in the chest. That's the law. Additionally, he had a gun pointed at him. He had nowhere to go, and he said something in the heat of the moment. It actually makes sense, because if what happened out there had happened, he had a gun being waved at him, he didn't have anywhere to go, and he didn't know what was going to happen. And so he said something. It really doesn't matter. Now, I appreciate that law enforcement did not arrest the defendant on scene, because it is important that our law enforcement does full investigations before they make very big decisions, like getting an arrest warrant for someone in our community. It is not a bad thing, and it is not something to be used against this investigation, that they did a full investigation before they made that decision. They would also like for you to believe that just because the victim said something like, "Get the F away from me," while he was at the hospital, that ultimately you shouldn't believe the victim because he said that. Look at the picture. This is when they're trying to ask him questions. He's in serious pain. Look at his face. It makes sense that he is telling people at that point in time, while he is fighting for his life with a bullet hole in his chest, for people to get away from him. So we spent hours this week going over all of the defendant's statements, and he gave a lot of them. And there are so many that I'm sure that it's been hard to keep track of all of the details. So I made us a chart. The defendant's story never made sense, it was not consistent, and it changed constantly. Regarding the word sacrifice, that was only mentioned on his first statement. Regarding the fact that the victim had a weapon, only on statement number 1, he says, "I don't know." So we know that this weapon is irrelevant. The fact that the fact that JC had a knife on his belt did not matter to the defendant. We also know that the only time that knife was even mentioned was when the defendant said, "Yeah, I have a pocket knife myself." We know that the only time prison was mentioned was after he had a chance to talk to an attorney and brought in a statement, and suddenly the fact that the victim went to prison was a big deal. But we know it wasn't, because he continued to hang out with all these people at multiple bars, at the Vistas, at their home, after they had learned about this. Changes the story between the different statements on whether or not Peyton was threatened at the car or not. And he never was able to articulate how she was threatened. It's all in his head, because he's drunk, being irresponsible, and handling firearms. We also know that the defendant is not consistent about that either. He only mentioned that Peyton was being raped in the first and the fourth statement. We also know that he even changed what he was talking about regarding the location of the shooting. First, in that statement, he said it was by the stairs. Then he said it was in the car park. Then he said it was in the carport and then in the carport. So he's not consistent. And if he wants to claim self-defense, then we need to look at the facts that he's given us, and they are not sufficient in any single one of these statements. We also know that he changed the location of where Peyton was, and it matters, right? If he's trying to protect his girlfriend, and if that's really his intent, where Peyton is matters, and he can't even keep that straight. First, he says it was that she was over there on the little cobble. Then he says she was near the stairs, and then she says, oh, he was in the back seat. We also know that he changed his story regarding the location of the gun in those 4 statements. First, it was in the center console. Then he kept it in the car. Then he moved it from the center console to between the passenger seat and the console. These are not consistent. But what is consistent is even if you buy statement 1, statement 2, statement 3, statement 4, all he says is that there was verbal provocation, which is not sufficient, and someone was walking. That's it. That is not sufficient for self-defense. That is not a reasonable belief. He does not have the right to use that deadly force because there was no knife, no deadly force being used, and there was no imminent sexual assault that was about to occur because he can't even articulate where Peyton is. And he can't articulate why he thought that. And he doesn't say what anything that the victim was doing to give him that idea other than walking. Briefly want to touch on this letter of this presumption. He cannot provoke the person against whom the force was used. He cannot do that. Him pulling a gun, even if you buy that the victim was coming at him, so going forward to him, it does not matter because the defendant had already pulled the gun.
We're gonna object to this, Your Honor, and we ask that it be taken off. That's gonna be contrary to your charge.
Your Honor, the
On
law.
B, Your Honor, it's got or, and your charge specifically has and. That's a misstatement of the law.
And you have to have 1, 2, and 3, and Your Honor.
Oh, I stand corrected, you. That's either or no.
So, as long as I prove one of those things, he doesn't get his presumption. Since he did not provoke, or since he did provoke it, he doesn't get that presumption. Also, he was engaged in criminal activity. He had pulled out a gun and was pointing it at someone. So he no longer gets that presumption. Since we went through the same thing with the defendant's stories, I figured it was important for us to talk about the victim and how their story did not change. We have sacrifice never being mentioned by the victim on either one of his statements. We have a weapon. The only weapon that he talks about is the one that he had. We also, and he was very upfront and honest about that. And he was the one who actually told us about the fact that he had shown the weapon at the bar. The defendant doesn't even bring that up. So he's being very upfront and honest about all of these things. But if you look across it, he's consistent. The location of the shooting, how the shooting occurred, where Peyton was, all of those things are consistent. Ultimately, what his actions are not reasonable, and it is not self-defense, and he was not justified in using deadly force against those individuals or against JC. Because the only thing that he ever describes in detail, he can't even describe specific threats. He can't describe specific words either. The only thing that he said is the defendant's walking, and in that 3rd statement, in that 4th statement, he describes it as an L. And he ultimately knows exactly where he was shot because in that picture it shows him at the very ends of the vehicle. So we have an unarmed individual walking to the right because that is what the evidence shows. And the defendant pulling out a gun and deciding to shoot him.
I didn't do nothing wrong, and you know what? You give me the chance, I'd do it again and again. Somebody tries to take what's mine, I'm gonna defend myself. Somebody tries to hurt what I love, I'm gonna defend myself. Somebody steps where they don't know how to step, and I tell them to get off, and they don't get off, I'm gonna defend myself.
You are the individuals that get to make the decision to tell this defendant that he cannot do this again. That pulling out a weapon when someone is walking around and saying weird things is not enough to pull a weapon. He has told you he would do it again. And we know how dangerous it can be when people pull out firearms. We need to make sure whenever you're going through this, that you do not take into account anything regarding punishment. Each one of you promised me in jury selection that you would not consider punishment at this stage of the trial. And each one of you made me that promise. So when you are going back there, you are not to discuss punishment at this time. What we are to discuss is the defendant's actions, what he did, and whether or not that we have proven our case beyond a reasonable doubt. Each one of you gets to decide what is reasonable and tell this community what is reasonable. You get to tell the defendant what is reasonable. And you get, by your verdict, to show this community that we not stand for irresponsible and dangerous use of weapons. Whenever you pull out your weapon, you need to pull the laws. And the laws are very clear that you have to have that reasonable belief. And the state has proven beyond a reasonable doubt, including through the defendant's own words, over and over and over again, that this was not reasonable. And so I ask that you pull up the very last page and on the verdict form that you find the defendant guilty.
Ladies and gentlemen, you now have all the evidence before you. You have the law that applies to this case. You have the closing arguments of the attorneys. I now give the case to you. We will be in recess until you reach a verdict. You may start deliberating.
All rise for the jury.
You may be seated. Anything you need to take up?
Nothing to say.
Second from the fifth.
All right. Jury's out at 11:02. Go off the record, Ruby.